This coming 21 February, the year 2012 court hearing of the criminal indictment of the Watchtower Society and the Faithful and Discreet Slave and the governing body of Jehovah's Witnesses begin in Australia. For reference, I have collected the info of the matter. You will hear the Watchtower Society and the governing body did not comply with the Victoria State Child Protection Law in Australia. Because of the brothers Stephen and Tank filing the case in July 2011, Watchtower Society was forced to comply with the law in September 2011. And you will also hear the lawyer of the Watchtower Society denied the existence of the Faithful and Discreet Slave in the court hearing in 11 October 2011. The development. Firstly, this is about the Working with Children check system. This month, June 2011, concludes the 5-year intake of organizations regarding compliance with the Working with Children laws. The Working with Children Act 2005 states in Section 1:1, the main purpose of this act is to assist in protecting children from sexual or physical harm by ensuring that people who work with or care for them have their suitability to do so checked by a government body. Working with Children check. The Department of Justice takes Mr. Untank's allegations seriously and has dealt directly with both Mr. Untank and the name of the religious organization on a number of occasions. Mr. Untank first wrote to the department alleging breaches of the act by the organization in July 2008. The department responded by referring Mr. Untank to the Sexual Offences and Child Abuse Unit of Victoria Police, emphasizing the importance that he report his allegations to the police. Correspondence was also sent at this time to the management of the religious organization in Australia, informing them of their obligations under the Act. Ministers or elders within this religious organization are required to undergo a Working with Children check under Section 9(3)(I) of the Act. Religious organizations, if their work satisfies the definition of child-related work under Section 9(1) of the Act. The department has written to the management of the religious organization in Australia on a number of occasions, most recently in November 2010, informing them of their obligations under the Act and offering to meet and conduct information sessions for their staff and ministers. Victoria Police have responsibility for investigations and enforcement of the Act. Professor Scott: Yes, I'd just like to say that I appreciate you bringing this to our awareness, this issue of compliance with the Act, and I believe it is within our terms of reference, and I think this has been very helpful. In my reading of the submissions to date, I think this is the first time that this matter has been raised as clearly as this, so I thank you for that. Mr. Scales, I just had one question just for clarification. Are you also arguing that those people, in this case you've raised it in relation to a particular organization, but in more general you're saying that those people are working across the breadth of work with children, for example in schools, kindergartens, all of these other areas? Mr. Untank, just a correction, they operate their own internal church schools for training and teaching and education. They're not schools and kindergartens as we understand, like a primary school or a private school. Each school operates on 50 days per year, and a normal school, as children attend for education by law, operates I believe on over 200 days per year, so these are small church-run schools. Criminal charges were officially filed today, 26 July 2011, in the Magistrates Court of Victoria, Australia, against the entire worldwide religious and corporate hierarchy of the Church of Jehovah's Witnesses. The charges allege ongoing breaches of the Victorian Working with Children Act 2005 as it applies to religious organizations. An initial 35 criminal charges alleging breaches of mandatory child protection laws were individually filed against the following corporations and bodies as named in the court documents: Governing Body of Jehovah's Witnesses, 7 charges; Watchtower Bible and Tract Society of Pennsylvania, 7 charges; Watchtower Bible and Tract Society of Australia, 7 charges; Christian Congregation of Jehovah's Witnesses, 7 charges; Faithful and Discreet Slave, 7 charges. All of the accused legally form part of the Committee of Management for the Religion of Jehovah's Witnesses in the state of Victoria. Each of the 35 charges carries a fine of up to Australian $134,000. All charges are in relation to allegations of unlawful activities carried out within the Traralgon Kingdom Hall of Jehovah's Witnesses by the entire body of elders within the Traralgon Congregation of Jehovah's Witnesses. All current members of the governing body of Jehovah's Witnesses are also facing potential arrest and charging in relation to each alleged offense as they knew of, or knowingly authorized or permitted, the commission of the offense. If convicted, the individual will face up to 2 years imprisonment per offense and even the possibility of being placed on the state's sex offenders register. It is expected that over 100 additional sets of criminal charges could be laid as more evidence comes to light and more offenses are formally identified. The filing of all 35 charges was formally approved by Victoria's Chief Magistrate after the Department of Justice carried out a thorough review of the evidence and application of the legislation and law as it applies to religious organizations, including within the religion of Jehovah's Witnesses. The first round of charges were then filed today, 26 July 2011, by Mr. Stephen Untank. Then in September 2011, the Watchtower Society, the Christian Congregation of Jehovah's Witnesses, the Faithful and Discreet Slave, and the governing body of Jehovah's Witnesses issued a special letter to all bodies of elders in the state of Victoria instructing them to immediately apply for their working with children licenses and to comply with child protection laws. The letter includes instructions that the contents are not to be made public or shared with members of the congregation. All court fees for the filing of the charges were donated by a number of children, through their parents, for and on behalf of all children within the religion of Jehovah's Witnesses. Following the filing of the charges, the Registrar of the Magistrates Court of Victoria, acting under direct instruction from the Chief Magistrate, formally referred a case to the Office of Public Prosecutions, which is the statutory authority responsible for preparing and conducting criminal prosecutions in Victoria. In relation to the seriousness of the charges and allegations of widespread child abuse and neglect within the religion of Jehovah's Witnesses, a formal submission to the Australian Senate is now being prepared for the purpose of requesting an immediate Senate inquiry into the alleged ongoing criminal activities being committed within Australia by the Committee of Management for the Religion of Jehovah's Witnesses. Many members of the religion of Jehovah's Witnesses and their families are now demanding the immediate resignation or removal of the entire governing body of Jehovah's Witnesses and the entire board of directors of the Watchtower Society, as well as the forming of church-based judicial committees in relation to these serious child abuse charges. This has been made even more urgent by the fact that every charge is an indictable criminal offense, with the victim being a child, and every alleged perpetrator being a current church elder holding a position of responsibility within the religion. In commenting on the filing of the criminal charges in the Magistrates Court today, 26 July 2011, Mr. Stephen Untank has released the following personal statement. The governing body of Jehovah's Witnesses and the Watchtower Society knew about these child protection laws and refused to comply from the outset. They were notified well before the laws were made compulsory for religious organizations. They ignored the counsel and the need to comply. They were then warned that they could face criminal charges. They did nothing about it and nothing to protect the children and nothing to protect the name and reputation of the church. Even the Department of Justice notified them and offered to assist them in complying with mandatory child safety laws. This included an offer to conduct training and information sessions. The state government had previously waived all the fees so that the religion could comply without a financial burden to anyone. The governing body of Jehovah's Witnesses and the Watchtower Society completely ignored the offer of help. Again, they were informed that they were still facing imminent charges and were given an opportunity to sort the matter out. They refused mediation. They were also given the opportunity to have the complaints of serious wrongdoing and allegations of breaches of child protection laws heard within the church format under the religious category of sins. They refused to even conduct an initial investigation to establish whether there is substance to the report and whether evidence is available showing that a serious sin actually has been committed. So now the complaints will be heard under the Criminal Code as indictable crimes. This was approved following an initial investigation by the Department of Justice to establish whether there is substance to the report and whether evidence is available showing that a crime may have actually been committed. These men are no longer free from accusation and neither do they have a fine testimony even from people on the outside of the congregation. They are no longer blameless. As of 31 March 2011, 738,563 adults from all walks of life within the Victorian community have formally complied with the Working with Children laws and undergone child safety checks to verify that they are not convicted criminals, so that they can continue their duties within the organizations they work or volunteer in and where children are present. The Victorian community will not tolerate any religious organization that refuses to comply with mandatory child protection laws with claims that their church elders and officers are exempt from child protection laws. They are not, and any claim of being exempt, regardless of who issued that claim, is an outright lie. The Department of Justice has not issued any exemption to any religious organization. These child protection laws apply to religious organizations by default. Children form part of every congregation of Jehovah's Witnesses. Elders are appointed by the Committee of Management for the Religion of Jehovah's Witnesses as overseers in each congregation. As overseers, they are continually instructed that part of their internal ministry involves shepherding the children and being available to assist children, help children, mentor children, and to encourage children to join the local congregation's ministry school as a student. This is called working with children. The governing body of Jehovah's Witnesses and the Watchtower Society have refused to comply with legal requirements in relation to the activities of their appointed corporate officers and representatives and elders. For refusing to comply, they have been criminally charged under corporate law literally in relation to their activities as corporate officers of a religious organization. This has never had anything to do with preaching activities and the preaching work of the members of the Religion of Jehovah's Witnesses. Those activities are protected under freedom of religion. The governing body of Jehovah's Witnesses and the Watchtower Society have always been made aware of this undisputed fact. They ignored the counsel and as a result have been charged with criminal offenses. You can't undo being charged. You can't hide being charged. You can't deny being charged. Once charged with committing criminal offenses against children, always charged. This is child abuse. Negligent child abuse that has resulted in being charged with the committing of criminal offenses against children. These men are no longer irreprehensible. They refuse to protect the children and the church. They abandoned the congregation and the children. And now that they are being held accountable, will they be the loudest to scream violations of human rights and freedom of religion and religious persecution? Not likely. Corporations do not have human rights. Only humans have human rights. Freedom of religion only applies to humans. It does not apply to corporations or unincorporated bodies and associations. And as for any claim of religious persecution, being held accountable for the committing of criminal offenses against children can hardly be the basis for one's claim of being persecuted. It's time for these men to be removed from their office of overseer. They themselves have gone on record and said that anyone in a responsible position who is guilty of child abuse would be removed from his responsibilities without hesitation. It's time for their own removal. Or will they have themselves declared righteous and claim that they are exempt from their own rules they enforce within the congregation? A total of 5 separate court hearings have been scheduled for 13 September 2011 in the Magistrates Court of Victoria at Latrobe Valley, with the accused to be served by summons to appear. Victoria, Australia. Report on October 11th hearing involving Stephen Untang. What we do know is that the faithful and discreet slave, FDS, have been criminally charged and are being prosecuted as corporate accused. We also know that there are 7 charges on their charge sheet and summons, corporate accused, in relation to the Working with Children Act 2005. We do not know what the charges are, as these have not yet been read out in court. This will happen in time, but until then it is anyone's guess. In all reality, the charge wordings are irrelevant. Under Victorian law, corporate accused can legally be an incorporated entity, a registered company, an association, or an unincorporated body. The FDS is not an incorporated entity, a registered company, and is not an association, no articles of association, so therefore the charge sheet or sheets must list it as an unincorporated body. During the court hearing on October 11, legal counsel for the Watchtower Society, Rachel Van Whitson from Vincent Toole Solicitors, the Watchtower Society's in-house law firm located inside Bethel, Australia, made a statement on behalf of the Watchtower Society that the faithful and discreet slave is not a legal entity. Vincent Toole Solicitors then went on to present arguments that the faithful and discreet slave do not exist as a person, nor do they exist as an unincorporated body, and nor do they exist as a body of Christians. Literally, Vincent Toole Solicitors were arguing that the faithful and discreet slave should be struck off the charged list because they simply do not exist. In one broad sweeping statement, the Watchtower Society and their in-house legal team completely destroyed the entire fabric and structure of the faith of some 7 million Jehovah's Witnesses. What next happened goes beyond the wildest imaginings that any Jehovah's Witness could ever believe was possible. Untang presented argument that the FDS was real and was that body of Jehovah's Witness Christians that had religious responsibility over the entire Christian congregation. The Watchtower Society and Vincent Toole Solicitors then presented rebuttal argument that the faithful and discreet slave did not exist but were nothing more than a theological arrangement. A massive gasp could be heard emanating from the gallery from amongst a group of Jehovah's Witnesses who had attended to watch the hearing. It is worth noting that Jehovah's Witnesses are taught that to deny the faithful and discreet slave is to deny the Christ, and that those who deny the Christ are the Antichrist. The Watchtower Society and Vincent Toole solicitors then turned on a Christian congregation of Jehovah's Witnesses and denied that they existed or operated within Victoria and Australia. Simply put, the Watchtower Society and Vincent Toole solicitors denied the existence of the faithful and discreet slave and denied the existence of the Christian congregation arrangement. The magistrate did not accept this argument and, after seeking approval from Stephen and Tank, adjourned all the court hearings for 4 weeks. The results of the fourth round of court hearings held on 6 December 2011, in relation to the criminal prosecution of the governing body of Jehovah's Witnesses et al., are as follows. Mr. Stephen Tank remains the acting prosecutor, and all 5 cases and 35 individual criminal charges are still before the courts. The Crown informed the court that the Office of Public Prosecutions are acting as a facilitator at the moment, that the police investigation is quite well progressed, and that the police are awaiting response from the Department of Justice. The magistrate acknowledged the complexity of the case. Court hearing summary: December 6, 2011. Acting prosecutor, Mr. Stephen Tank. Case number B12083527. Accused, governing body of Jehovah's Witnesses. Case number B12083108. Accused, Christian congregation of Jehovah's Witnesses. Case number B12083367. Accused, faithful and discreet slave. Case number B12082206. Accused, Watchtower Bible and Tract Society of Australia. Case number B12083833. Accused, Watchtower Bible and Tract Society of Pennsylvania, Inc. The accused again failed to appear and was not represented by legal counsel. An application was made by the Crown, the Director of Public Prosecutions, for an adjournment for 10 weeks so that Victoria Police could finalize their current investigation and receive further information from the Department of Justice. Results: the case was adjourned for 10 weeks. Next court hearing date: 21 February 2012. At the request of the Office of Public Prosecutions, all 5 cases were adjourned until 21 February 2012. Link to Magistrates Court of Victoria official criminal trial listings for February 21, 2012. http://bit.ly/fiona